Hi, hello, and welcome to my channel, friends. This is your Govindaraj. Thank you very much for all your views and subscriptions, likes, and comments on my previous videos. And thank you for sharing my previous video to all your contacts. In the previous video, we discussed about 6 reasons for employees to be happy with Social Security Code 2020. And in this video, we are going to discuss 10 reasons for employers to be happy with Social Security Code 2020, or we call it as the Code on Social Security 2020. And let's begin this discussion, friends. So, before we proceed, let's quickly understand what is this all about Social Security Code 2020, or the Code on Social Security 2020. And this piece of legislation amalgamates 9 legislations or 9 labor laws which were available on Social Security, which are employee compensation, employee state insurance, employees provident fund, employment exchanges, compulsory notification of vacancies act 1959, the maternity benefit, the payment of gratuity, senior workers welfare fund, and the building and other construction workers welfare act, and also the finally the unorganized workers social security act 2008. And the code on social security amalgamates these 9 legislations which were existing today. And if you look at the entire these 9 legislations, the provisions contained in 256 sections and 10 schedules among these 10 legislations are now amalgamated into 164 sections and 7 schedules. And if you look at 2019 bill, this bill had 163 sections and 6 schedules, and with the 2020 code which is already passed and waiting for the implementation has got 164 sections and 7 schedules. Now let's proceed into why employers have to be happy, and also I'm going to give you 10 reasons for employers to be happy. The first one is we need to deliberate who is responsible for payment of social security contributions to contract employees like provident fund, ESI, gratuity, maternity benefit, and all other social security contributions. Now the question is whether contractor or the principal employer. This is always a conflict and debatable questions, and we used to get into the interpretation of each individual legislation, either the application clause or the employer definition or the wage definition or the employee definition. So these are the definitions we used to resort to come to conclusions, and also we used to look into judicial pronouncements on these topics. Now let's understand for the benefit of employers and how this will be dealt in the future. See, in case of ESI and PF, the code still mandates the principal employer to pay at the first instance. And however, if you look at the code, the definition of employer includes contractor as employer as well. And the current law, if you look at, it is based on judicial pronouncement, is that the principal employer is not responsible if the contractor has independent code numbers. And the same interpretation in the new case should hold good. And moreover, if you look at the code, the contractor is also an employer as per the code and is equally liable. However, a caution for employers: employers have to be careful while selecting contractors who have no ESI and PF code numbers, because the liability can always be put on principal employers. Because also, if you look at the employer and employee definition, both covers employees who are directly or indirectly or through any agency employed. Therefore these definitions also include contract employees. So the employers have to be very cautious if they are going to engage contractors who have no ESI and PF code numbers or who have no registrations under these legislations or the code. Now let's come to about gratuity, maternity benefit, and other statutory benefits. In case of the gratuity, the current law holds contractor responsible for gratuity, And now if you look at the code, the contractor also is included as an employer. The current law is based on the Contract Labor Regulation and Abolition Act, and also Payment of Wages Act and the Gratuity Act. So all these three legislations put together, the judicial pronouncement held that, or the courts of India have held that, the contractor is responsible for payment of gratuity. And this situation may undergo a change, because I have already told you, if you look at the employee definition, it covers employees employed directly or indirectly or through any agency or through any contractor. And whereas the employer also includes who has employed employees directly or indirectly. The good thing is the contractor is specifically included as an employer. Therefore, the contractor can also be held responsible for payment of gratuity, and for this the terms of the contract are required to be precise, and these terms of the contract with the principal employer and the contractor have to be very precise, and also should contain the obligations of both principal employer and the contractor. As per the Employees Compensation Act 1923, the principal employer is liable for payment of compensation in case of employment injury where the employees are not covered under Employee State Insurance Act. And in the code also the same status is maintained. However, employer has a possibility to bind the contractor if the appropriate terms are included in the contract. So therefore I said, please look into your contract and see that these obligations are clearly defined in the contract between the principal employer and the contractor. And in case of maternity benefit, both contractor and principal employer can be held liable if the terms between the principal employer and contractor are not properly defined in the contract. Because if you look at the definition of woman in the Maternity Benefit Act and also in the code, it includes whether employed directly or through any contractor. And as far as the Maternity Benefit Act and the code is concerned, every woman is protected and every woman should be given with the facilities provided under the code in case of maternity benefit or in case of Maternity Benefit Act. So therefore, the binding contract between the employer, principal employer and the contract employer is very important, because both these people can be held responsible for the compliance of these provisions. And therefore, as I said friends, it makes more important to have the proper and appropriate contract between the contractor and the principal employer. If the obligations and responsibilities are very clearly defined, then it is very easy to come to conclusion and compliance part of it. Otherwise, the principal employer can also be held responsible and the contractor can also be held responsible, and it can also happen that if the contractor fails, then ultimately the principal employer will become responsible for these social security benefits for contract employees. Now let me give you the second reason why employers have to be happy. Now if you look at the code, or if you look at the labor codes, the fixed term employment is now an explicit provision, and in the previously and in the current law, the fixed term employment is not an explicit provision, even though it was available in the Industrial Dispute Act section 200 of the act while defining what is a retrenchment. So therefore, it is important that to look into the provisions of the code and also the IR code. The fixed term employment is now an explicit provision. Currently, it comes with various issues, but we don't see certain restrictions which were available in the old bill and current status as well. And this can become a game changer in the Indian employments if it is accepted by the courts in the same spirit as the law wants to implement. If you look at how the fixed term employment has been evolving from the implicit provision to explicit provision, and when the amendments were taken place to the Employment Standing Orders Act, initially these concept has certain restrictions, like the permanent jobs cannot be converted into fixed term employment. So all these conditions were there. Now in the revised law in the labor codes, which is especially the IR code and also other connecting codes like social security code, now it is an explicit provision and there are no such restrictions like permanent jobs cannot be converted as fixed term. So therefore it can become a game changer if the courts accepts the law as it is being implemented through the labor courts. And on this topic we have dealt in detail about the nuances of fixed term employment and various other connected questions and answers and details. You can watch these two videos and get to know more about this topic. And also if you look at the provisions related to fixed term employment, employer is also required to pay gratuity and other statutory benefits irrespective of whether he qualifies as per the statute or not. So there is no escape for the employer on the social security benefits, even though if he does not qualify, because there are certain threshold qualifications. If even if it does not meet, then the statutory benefits and the statutory contributions or social security benefits have to be extended on pro rata basis. These provisions have been brought under the code. Therefore the employer cannot escape from the responsibility of these statutory liabilities or social security benefits for these employees as well. Now let me give you the third reason why employers have to be happy with the social security code. And if you look at in the case of provident fund, when the employer has decided to proceed for an appeal against the orders of the PF authorities, the employers are required to deposit certain portion of the amount which were as calculated by the PF authorities. Now the law is getting changed, because if you look at section 7(o) of Employees Provident Fund and Miscellaneous Provisions Act 1952, this law mandated deposit of 75% of amounts due if the appeal is preferred to the tribunal. Now this is going to change. Section 23(3) of the code prescribe that 25% of the amount due needs to be deposited and not 75%. However, if you look at both the provisions, section 7(o) and section 23(3), in the old law, tribunal had the power to waive or reduce this deposit portion. Now we do not see such a provision in the new code. However, reducing it to 75 to 25%, it is a big relief for the employers. Now let me give you the fourth reason why employers have to be happy with the Social Security code. And if you look at the Maternity Benefit Act and the code, the employer is required to provide creche or creche facility for women employees who have kids under the age of 6 years. So the employers are required to provide creche facility at their location. Now in the code, possibility to have common creche facility by pooling their resources in their area, or possibility to avail any creche facility set up by government or non-governmental organization or any other private body. This provision has been incorporated in the code. I am not saying that this provision was not available in the old law, because if you look at the Maternity Benefit Act, there was no specifically these provisions were provided that they can outsource this facility. Now the explicit provisions are brought in the code which are very beneficial for the employees. As I said earlier, as per Maternity Benefit Act 1961, every employer employing 50 or more employees is required to provide creche facility for the women employees who are having kids less than 6 years age. And now the new code talks about every employer employing 50 or such number of employees as prescribed by the central government is required to provide creche facility. Now the 50 employees criteria is still there. However, the central government retains the power to vary this number of employees limit. Now let me give you the fifth reason why employers have to be happy with the Social Security Code or Code on Social Security 2020. Maintenance of documents, records, registers by electronic mode is now explicitly included in the code. This facility, I am also not saying that this was not available in the old or the current law. This was always brought in by way of an amendment, and you were supposed to seek an approval or give an information to the authorities. Now these provisions are being incorporated in the labor codes, and now it is there are explicit provisions that even if you maintain electronically all documents and submit all your returns electronically, that is sufficient compliance of the law. So this is important relief and major change which is being brought in the code. Now let me give you the sixth reason why employers have to be happy with the Social Security Code. And going ahead friends, web based randomized selection of inspection and calling of information electronically will be a reality, and both governments are required to lay down inspection scheme to implement these provisions. When I say both governments, it is both central government and state governments have the responsibility and obligation to lay down appropriate inspection scheme to implement these changes and provisions. And this provision or measure will give a way for faceless inspection and reduce difficulties for employers which are being faced due to bureaucratic processes, and this is a major big relief if these are being implemented without any clutches or difficulties. Now let me give you the seventh reason why employers have to be happy with Social Security Code 2020 or Code on Social Security 2020. Limitation for recovery of dues from employers is now fixed at 5 years for all the dues under the code. You can take it employee state insurance, provident fund, or any other contributions which are required to be paid under any other social security scheme. See, the dues from the employer which belongs to more than 5 years cannot be recovered now because of the section 125 of the code. Now previously what used to happen is ESI Act had this provision, but there was no such express limitation or provision in case of provident fund. Now any authority want to recover the dues from the employers and want to assess the dues from the employers, now they have a limitation period of 5 years, and beyond 5 years no authority can get into and assess the dues and claim the dues from the employers. And this is also very big relief for the employers and a very big measure brought in the code. Now let me give you the eighth reason why employers have to be happy with the Code on Social Security Code. If at all any inspector come facilitator wants to prosecute the employer for any violations under the code, prior opportunity for employers before prosecution to set right the non-compliance within a period or specified time frame is required under the code. The inspector cum facilitator cannot straight away go and prosecute the employers because of the new provisions under the code. And as I said, inspector is bound to give this opportunity, and no prosecution will happen if the employer complies the directions or fulfill the non-compliance within the time frame given by the inspector cum facilitator. You can look into section 137 of the code, you will get these provisions. However, employer will lose this opportunity if the similar nature of violation is repeated within a period of 3 years, and this 3 years period was in the wage code, it was 5 years, now it is reduced to 3 years. Now let me give you the ninth reason why employers have to be happy with Code on Social Security 2020. Now employers can compound the offenses under the code. See, this compounding or composition of offenses is more predominantly used or available in the criminal law. now this has also been brought into the labor laws to compound the offences. Now let's look into certain key provisions in this regard. First time offences punishable with fine can be compounded by paying 50% of the maximum fine amount specified, and first time offences punishable with imprisonment for not more than 1 year can be compounded by paying 75% of the maximum fine amount specified. However, this is not available for the similar offences second time or committing an offence within a period of 3 years from the date of earlier compounding or earlier conviction, and any default of the compounding orders will land in additional fine of 20% of the maximum fine provided for such an offense. So therefore employers have to be careful while utilizing this opportunity. When they use this opportunity and they don't honor the order, they will have to pay another 20% of the maximum fine which is provided in for such offenses. Now let me give you the last reason why employers have to be happy with the Social Security Code 2020 or Code on Social Security 2020. Now, Social Security scheme can be formulated with the sources of corporate social responsibility funds. What is the benefit for the employers? So the benefit is the contribution to any such schemes where the CSR funds are accepted as a source. Employer can utilize this opportunity to discharge his responsibility on CSR spending. So therefore it is a beneficial provision for the employers. If there is any scheme which has got a CSR funding, employer can choose to pay their CSR earmarked amount for these kind of schemes and for the good of the society. So this is also a one of the benefit from the Social Security Code for employers. So friends, thank you very much for watching my video so far. If this piece of information is useful to you and increased your knowledge on the Social Security Code, please do share this video with your contacts, and please like the video, comment the video, and also continue to watch this channel for more updates on labor codes and labor relations. Thank you very much friends, and see you soon in the next video.